how do you feel about this is a past scenario, what actually happened? The PECO and Exelon merger, and they kept jobs, a certain number of jobs there. They had benchmarks to meet. How do you feel about that type of situation, where if you would have a merger, that they would keep so many jobs this year and make sure that there was an upholding of those positions?
Well, the Commission approved that. In fact, the parties agreed to to maintain jobs for a certain period of time in Pennsylvania as a part of that PECO merger, because, of course, there was a concern about losing jobs in Pennsylvania to Illinois. The Commission is a regulator. The case law says we can't be a super board of directors of the company, but on the other hand, we use our authority to strongly suggest to utilities that they do certain things. I wasn't on the Commission when that vote occurred, but I would heartily endorse that approach, so that the impact on Pennsylvania, if there are going to be job losses, that they may be minimized over a period of time.
Wasn't that part of the contract? Wasn't that part of the final negotiation?
There was a settlement in that case, in which the parties, all the parties, including the company, of course, agreed that they would phase out any diminution in job reductions. I mean, they would phase out jobs over a period of time. So that could happen again, and I wouldn't be surprised if for instance, in a certain merger that is pending now, which I can't talk about too much because it is pending, that affects your constituents, I wouldn't be surprised if the parties would come up with something like that, and I'd be happy to vote for it.
Secondly, you have benchmarks. There are benchmarks that have been set out that so much of the power has to come from solar and so much of it has to come from wind by a certain year.
This is a part of the Alternative Portfolio Energy Standards Act.
Mm-hmm. What is the cost of solar compared to electric?
It is much more expensive than can be generated with a nuclear power plant or a coal plant. And that's the reason why you and the legislature have phased in or ramped up the requirements for alternative energy as a part of each for each company to deliver. In other words, it has started small, knowing full well that it's more expensive at this point, with the hope that by the time that the requirement ramps up, that technology will drive down the cost of solar and other alternative resources. If that doesn't happen, then I would expect you would modify the phase-in period to reflect the fact that the costs have not come down.
Just a little bit further on that issue, Secretary Hanger, as an intervener in this merger and a big solar supporter, could an intervener in this merger, I'm not going to talk directly about, I'm just going to try to do the best I can here without crossing a line. Could an intervener in this merger demand that we have more of something? Could that be part of a final negotiation, that we have more solar power? I guess what I'm asking is, could we be trading solar panels for our 953 white-collar jobs?
I don't think so. I'm not sure exactly how that would be proposed. Are you suggesting that the company would promise to put in more solar in exchange for being able to eliminate jobs quicker? I'm
not suggesting that come from the company, but from interveners that have their own agenda that could force it at the end. Everybody has to agree, correct?
Yes. I mean, anybody can suggest anything they want in a rate case. Now, whether they can prove it and whether they can get it as a part of an overall settlement is quite another matter. We have on occasion adopted non-unanimous settlements, but it's pretty rare. So again, they can propose it, but they may not get it adopted by everyone else, and we may not approve it. By the way, we don't always accept settlements. We've rejected certain settlements and said, I'm sorry, we just don't think certain elements of the settlement are in the public interest.
Okay. This isn't a great rate case. This is a merger. Okay.
On mergers, the legislature has given us very broad authority to protect the public interest. And what that means is that we can attach conditions to mergers that we view in the public interest. Typically what happens is that a record is made, public input is taken, the parties very often come up with a settlement, and the company usually has to agree to a number of conditions in order to get the parties to settle. And if they don't, the issues that they can't resolve, then the commission has to break the dispute or settle it.
Okay, well, and I'm going to publicly now, assuming, maybe I shouldn't, but assuming that you are reconfirmed, Public Utility Commission to come out to Greensburg and do some public hearings, and I'll be following that up with a letter. Thank you.